The International Criminal Court is a judicial institution reliant on the mandatory cooperation by states parties to execute the court's decisions. As such, cooperation between the court and the states parties has been extremely important since the establishment of the organization. The Rome Statute does not only create an individual court, but a comprehensive system of international justice that requires the active support and involvement in particular of states, international and regional organizations, and civil society, among other stakeholders. Cooperation is therefore a linchpin of this system of justice and an important pillar of the Rome Statute. It is the recognition that the court and the international community share the same goals and that they can only be achieved when working in concert. As such, cooperation has reciprocal benefits and obligations. This means that a court cannot fulfill its mandate without the collaboration and partnership of states, and the international community cannot achieve sustainable international peace and security without justice. Non-cooperation, however, has a heavy cost on the court's ability to implement its mandate, and therefore on its legitimacy and reputation, as well as that of its states parties and of the international justice system as a whole. The court's ability to protect its witnesses is a cornerstone of the ICC's ability to fulfill its mandate. The adequate protection of witnesses plays a key role in the successful functioning of the court, aiming at ensuring that witnesses testify freely and truthfully without fear of retribution or suffering further harm. The statutory framework of the court makes it clear that the court has a duty to take appropriate measures to protect the safety, physical and psychological well-being, dignity and privacy of victims and witnesses. Witness protection is also fundamentally important for both the prosecution and the defense to present their cases in court. As registrar, I have a responsibility to facilitate the rights of the defense consistent with the principle of fair trial. One aspect of this is assisting the defense teams in obtaining cooperation from states, so that they may operate on an equal level with the Office of the Prosecutor. If the ICC lacks the capacity to properly protect its witnesses, it will inhibit the parties' ability to present their case, undermine the ability of the court to provide due process, and impinge upon the efficiency of proceedings and the length of trials. To meet its obligations, the ICC takes a number of measures to protect its victims and witnesses, right from the investigation stage. These include a variety of protection mechanisms, such as local protection measures, meaning to install locks, provision of phones, and cooperate with local law enforcement on local security arrangements. Procedural protective measures, introducing voice and facial distortion during the trials, pseudonym, and ICC protection programs as a last resort measure, including permanent relocation of witnesses and families to another country. The relocation agreement is a bilateral agreement between the ICC and the state that agrees to host in its territory victims and witnesses threatened due to their interaction with the court. Under a relocation agreement, the member state normally agrees to both host the persons at risk and to financially contribute to their relocation. It is important to note that bilateral relocation agreements do not create an open-ended obligation for states to accept ICC witnesses. The agreement constitutes a framework under which the court will approach states on a case-by-case basis in order to explore the potential relocation of witnesses to its territory. To date, very few states have entered such agreements, making the work of the court more difficult. At the moment, only 14 of the 122 member states have entered into relocation agreements with the ICC. Should the court not be able to urgently relocate witnesses to a safe haven country when a life-threatening situation for the witness materializes, there is a serious risk of having a witness in grave danger. In addition, through the conclusion of relocation agreements, the court could assist with the transfer of expertise to national authorities in the field of witness protection. Such assistance could also strengthen the national witness protection capacities in general, thus enabling effective bilateral and regional cooperation for the investigation and prosecution of all serious crimes. In order to facilitate relocation of witnesses to take place, the registry established a special trust fund whereby a state party can donate funds for the benefit of another state accepting relocation. This fund was created in recognition of the financial challenges faced by a number of countries willing to consider concluding witness relocation agreements with the court through a cost-neutral arrangement. While progress has been made, more work is needed to strengthen cooperation between states and the ICC. Such cooperation is central to the successful functioning of the court and to ensure that judicial proceedings are not hindered or delayed by lack of or unsatisfactory cooperation. Our shared goal continues to be build an institution that fully delivers its mandate of justice and accountability. It is our collective duty to ensure that the court is strong, credible, and that it prevails. But we can only achieve this together. I hope that my presentation has brought the International Criminal Court as an institution a little closer, and that the essential role that must be played by the states parties in terms of cooperation, witness protection and relocation agreements has become clearer. Thank you for your attention and your support to the ICC.